Hey Rodney, good
Hey man, how
evening.
are you?
I'm okay.
Good
How are you?
evening. I am okay. I'm as well as can be.
Okay, that's good. That's good. Good evening, everybody. Welcome, all of you guys who are joining us on a Friday night. We're happy to have you here on a Friday night. Welcome to our Friday segment where we try to solve some entrepreneurs' questions or try to solve some business owners' issues that they may have. And today's topic is very, very interesting. It's about debt, right? So if you're in debt and due to COVID-19, some of you guys may be affected. Um, and tonight we actually have Mr. Rodney Koh, a corporate lawyer, to share. If you remember, actually Rodney was back was actually on a show earlier on actually a crypto session regarding legality around crypto sessions. So tonight we're very happy to have you here. Thank you, Rodney, for joining us.
Thank you for having me.
Okay.
Thank you.
Now, for those of you guys who can hear us, can you just give us a blip at the bottom to say that yes, you can hear us? Just to say yes, and we know you guys can hear us loud and clear, either on Facebook or YouTube. Yeah, and thank you for joining us on a Friday night. It's the weekend already, right? So quickly. So we know Ronnie has something prepped for everybody here. And he worked quite hard behind the scenes. So even if you're watching a recording on this, thank you. Thanks everyone. Even if you're recording, yep. So everyone can hear us. So if you're watching a recording of this, this may help you if your business may be in distress or in too much debt. Yeah. Okay. Great. Thank you, Jason, and everyone else for just confirming. Great. Okay, so let's get. I know Rodney has something prepared, and we're
Mhm.
happy to, as usual, the Q&A uh, to at the end of the show. Just keep posting any questions. If you guys have anything, just post it at below, and we can ask Rodney some of these questions. All right. Now, very quickly, just before we continue, there's a disclaimer. Whatever we're teaching here is educational. It is not legal advice or financial advice at this point. It's just trying to help content to educate you guys. For those who are running a business, if you're an entrepreneur or somewhat, if your company, if you have debt, right, what can you actually do? All right. So Rodney, over to you. Take it away.
Alvin, thank you very much for having me back this evening. It really is. I had a lot of fun doing that crypto segment with you and your brother. So you asked me to come back on again. I thought, yeah, well, first time wasn't bad. Let's see how a second time goes. All right. Um, Good evening, everybody. Welcome to this evening's short session. Um, what we're going to do essentially is dive into and try to at least outline. I can't possibly give any legal advice. I'm just going to try and outline what options there may be open to companies that are facing financial difficulties given the current climate that we are in. All right. So what I'm about to do is about to share my screen, and I'll take you through some slides. The slides I have prepared, and I understand those slides will be available for download after the session is over. So those slides, I hope they will serve as a useful reference, short and useful reference for all of you. So let me click share screen. Share screen looks best on the computer. Don't show this share screen. You may only use no need share screen. I am going to do an application window, companies. Okay, so
Yep. Got it.
yes, yep, that's up, right? Everybody can see it. Okay, right. So, all right, tonight topic of my discussion is companies in financial distress. Is there a way out? Options other than liquidation under the Companies Act 2016. Now, we all know what's happening right now economically, and I believe that it's really the word commonly thrown about as unprecedented. And it's true, because this is the first downturn that I've seen in almost 30 years, over my 30-year career, where we are seeing cash flows very severely affected. Sectors are actually prohibited from operating. We're talking particularly the entertainment and certainly some of the food and beverage sectors have been restricted, especially pubs are not allowed to open. And unlike downturns, there is no silver lining among the clouds. Previously, in previous downturns where it was caused by distress on the financial systems, at the very least, we still had our commodities or oil prices to sustain the economy, to sustain us going. But this time around, we've actually seen every sector, bar the health sector, health product sector, that's actually suffering a severe drop in demand and cash flow. So obviously, when we're talking about cash flow, we talk about debts. Okay, companies that actually have debts. Many companies are geared, and that is what should actually grab our attention, especially since the moratorium on banking debts will expire come early October. Okay, so now the Companies Act has always had ways to deal with indebted companies itself. Okay, they always had. Previously, under the Companies Act 1965, the old Companies Act before this one came into force, there was only two things that you could do: number 3 and number 4, or scheme of arrangement or liquidation of any of the company. But now, under the new Companies Act, there are two other alternatives aside from the scheme of arrangement that has now come into force. All right, one is called a corporate voluntary arrangement under Part 3, Division 8, Subdivision 1, and the other one is judicial management, Part 3 again, Division 8, Subdivision 2. All right. So what these three schemes, in fact, are actually fairly similar. They're not exactly similar, fairly similar, and they serve different segments, segments of the corporate world, corporate market. So what I'm going to do tonight is actually concentrate on 1, 2, and 3. Okay, I'm going to leave 4 for another session, perhaps another day. But 1, 2, and 3 are important because these three are ways you can rescue an indebted company, okay, without liquidating the enterprise. So what I'm going to and I would like to start with number 1, corporate voluntary arrangement, and I'm going to take a bit of time explaining the steps in the corporate voluntary arrangement, because once you get back, judicial management and scheme of arrangements are almost similar. So I will concentrate on the differences in relation to those two. Okay, right. So let's start with the first way you can deal with this, first of 4, which is called corporate voluntary arrangements, right? What is a corporate voluntary arrangement? Well, a corporate voluntary arrangement is where you enter into an arrangement with your creditors, right? To either renegotiate the debt or to restructure the debt by swapping some of the debt into equity or having some form of forgiveness of part of the debt in itself, so that in order that your company can survive a downturn, okay, an economic downturn. All right. Now, of the 3 debt management procedures, this is the simplest, and however, it's also the most limited. Okay, corporate voluntary arrangements are not open to companies which are public companies. So if it's Berhad, no, you can't do that. Financial institutions or listed companies under the CMSA. So in effect, listed companies can't take care of them. And also, it does not cover companies which have granted security over its assets. So the only companies that actually can avail themselves to this particular section of the Companies Act are private companies that have no borrowings from banks. Okay, you can have private companies that have borrowings from shareholders or directors, but certainly not from banks, because banks will inevitably ask for security over the assets of a company. So unfortunately, this limits its usefulness a great deal. But nevertheless, it's still worth having a look how it's done. Okay, all right. Okay, so when can a CVA happen? Let's say we have a company that is in financial distress, a private company, family-owned company, a business that's in financial distress. It owes a lot of money to its suppliers, for instance, okay, all right, and therefore needs a workout plan. So this plan can actually be initiated either by the directors or by a creditor or a judicial manager or liquidator, all right? The terms judicial manager and liquidator, these second two, I will explain later, all right? They will have to propose a person called a nominee, all right? So a nominee is a person who is a qualified insolvency practitioner. Essentially, they are accountants who specialize in turning around or debt renegotiation or restructuring matters. Okay, they are usually professionals with many years experience in audit and tax and matters like that, and they do this essentially day in day out. All right, and you can find them in just about every medium to large accounting firm in the country itself. So the nominee is a qualified insolvency practitioner. All right. Okay, so what the company does is that, okay, say a creditor, or especially normally in the case, the director say, we are in trouble, we need someone to help us, all right? So what they will do is they will hand over all relevant information about the company, its cash flow, its creditors list, its debtors list, and give it to the nominee, okay? And they will give the nominee a plan, what they hope to do. What the nominee must do is look at the plan and revert with a written opinion. He or she must come back with a written opinion that covers three things. Number one, the proposal has a reasonable prospects for success. Number two, once the cash requirements or the debt burden is being reduced, the company has enough funds to run its business. It means it becomes viable again. And the third thing is that this is such a worthwhile plan that creditors ought to be called for a meeting. Right? So they need to all come in, call for a meeting, and to discuss what the proposal is. Right? Why these steps become important is because in years past, especially during the 97 and 98 Asian currency crisis, right, under the previous act, there was the old Section 176 of the Companies Act 1965. And all that was required actually to initiate the company, that particular section, was essentially a proposal of a plan. That means the directors can say, we have a proposal and we want to put the proposal to our creditors. All right. But whether the proposal was any good or not didn't matter. All they had to do was put something down on paper. Okay. And having to put something down on paper itself, whether it was good or bad, well, it didn't matter. So when they went to court, they will ask for, they will apply for this, and then ask for a restraining order against any actions that may be taken against the company. So creditors may be suing them for money, banks may be chasing them for money. Suddenly, all these things stops. And guess what? Many of them just left the matter there. There was no time limit as to when the restraining order should expire. All right, okay, and many of them abused that section by just filing 176 orders and did nothing thereafter. So you can imagine how much problem that created. So that's why under the new regimes and the present ones that we have, you've got to have a real plan first, in the first place. A real plan that the nominee looks at it and says, yeah, this one has a fair chance of working. All right. So you got to have a plan. All right. And the second thing is then then the company files into court an application, all right, that includes the plan, okay, all the details concerning the company itself, and also, of course, the nominee statement. That means the nominee's written opinion saying that this plan has a chance of succeeding. So that the court will now no longer be abused by just filing plans to get protection. Because one of the good things is that once you put a plan like this in and you meet all the requirements that it is actually a viable plan, the court will then order that the CVA, what I call the corporate voluntary arrangement, be actually put into action. That means in our order that this thing be actually put into place. And once that's done, okay, a moratorium comes into effect. Okay, a moratorium is essentially when the day the order is done, a moratorium would say that all actions or debts or claims or court cases against the company will be stayed it will stop. Right? Nobody can continue with winding up the company or suing him for debts or matters like that. So that gives a period of protection for the company. And the purpose of this moratorium is so that the company has breathing space. The nominee can get to work putting the plan into effect. Okay. Now the duration there are actually now fixed durations for every type of debt workout plan. In the case of a CVA, the duration is 28 days. All right. You only have 28 days, and it can be extended by a further 60 days. All right. If a simple majority of creditors representing 75% of the total debts approve it. What it means is that once you go to court and the court says, yes, this is a reasonable prospects for plan, the court will say, put this plan into action, you need to call for a meeting, all right? Let the creditors have a look. So they need to actually convene the creditors meeting. It has to happen within 28 days, right? So that's a very tight timeline. And generally, the creditors will extend the moratorium by 60 days by a simple majority, all right? So, so this is the protection the Companies Act gives to the company, okay, while this plan is put to effect, all right? And how will people know that this plan is actually already put into effect? Well, there is compulsory notification procedures. First things first is that once you get an order that the CVA is to be implemented, the company must inform the registrar companies, they file that thing. The nominee must also confirm that he is aware that there is a moratorium and when the moratorium starts and ends, okay? And also advertise on the website of the company's commission and on one English and one Malay daily newspaper that a moratorium against any such action is in effect. So when that happens in itself, when a moratorium happens in itself, the company, if they are currently being sued, the lawyers can go to court and file and say, this is a moratorium, it's already there. Then the entire action is stayed, is put on hold. Nothing further will happen. So the nominee, having had have all these matters all stopped, now needs to call for creditors meeting. Okay, a notice is given out. All right, with a sufficient 14-day notice, all creditors are to come for a meeting. All right, in which this proposal will be actually tabled to them. Now, what can this proposal contain? Usually, when you're talking about small companies with no bank debts, no securities, these proposals essentially would call for either a reduction in the debt owed, some haircut on the creditor's part, or you give asking for further extension of time, or that in exchange for some of the debts, creditors are given preference shares in the company, and all these sort of general proposals are really on the table and up to the creditors to accept or otherwise in itself. Okay, so it's a way of saying, please, let's consider the company if you do this, we have a good chance of turning it around, and you're appealing to the good senses of the creditors and saying, if you do this, it will be better for you. All right, you will collect more money, and you will in fact come out better than winding up the company itself. All right, okay. So that's what a creditors meeting is to take place. All right, for it to finally be approved, okay, the proposed voluntary arrangement to be approved, the rule is that creditors holding no less than 75% of the total debt, all right, total debt of the creditors present and voting, and also represent a simple majority of the creditors present and voting, all right, must approve the debt itself. Okay, they must approve the scheme. Right. Once is actually approved, fulfilling these two criteria, the scheme is then binding on all the creditors and the company and everybody. It becomes automatically by law like a contract that everybody enters into and nobody can get out. It covers everyone. Right? The creditors, in the course of that, may well say, okay, now that we've agreed to this, we need people to make sure that this is done properly. They can, in fact, at that point, propose to set up a committee, which is either comprised of representatives of themselves, to come together and to oversee the implementation of this scheme. All right, okay, they can actually have a committee to do so. The committee generally would have two or members from the biggest creditors and some other ones that will actually sit with the nominee as they implement this scheme through and report back. So, okay, all right. So once the scheme is actually approved, the nominee is now called a supervisor, because his job is that the nominee has said, okay, I put the scheme, it's been proposed, been accepted. Then he becomes like the guy that actually implements it. All right. And during this period, the nominee or the supervisor, together with the committee, will make sure all the agreements are drawn, everything is all signed up. Okay. And then once that is all done, all put in place, everybody is happy. The supervisor goes back to court and files a certification to say, all right, this scheme has been fully implemented. Okay. Once that is done, the scheme is fully implemented. If the moratorium is still in effect, the moratorium ends, or if it and the matter is closed. So the company then has a new lease of life going forward under a lower burden of debt. Okay, and so that has a chance of turning things around. So that is essentially how a corporate voluntary scheme will work. Okay, it is not much. It is actually fairly simple step. It's like the court asking everybody come together, work out a deal. Everybody accepts the deal. We will give our judicial approval of the deal, and they go forward, and that gives a chance for the company to survive.
So,
right?
Rodney, can I just ask a question?
Yeah.
You mentioned just now the first item.
Mm.
So this does this include bankers as well? So if you have a loan outstanding that is not collateralized, for example, let's say the bank is saying, hey, you gotta pay up. Can they be part of this group of creditors?
Yes, they can. As long as as long as the company has not granted any security in its assets, you can use a CVA, in other words, a corporate voluntary arrangement. But if a company, and this is the more common case, if a company actually has granted securities like a fixed and floating charge over all its assets, okay, or a charge on property. Sometimes companies do charge on properties so that they can actually get trade financing, or they bought property on a loan, so they have to charge property. Then you use this mechanism called judicial management, and that's where the difference lies. Okay, right. So, that answers your question, Alvin. Can I jump into judicial management? Okay, right. So, so now we are going to judicial. Now, the difference is in judicial management. It's quite different in some very salient sense. Okay, all right. Again, there are certain companies that cannot do judicial management. That means those who are financial institutions, the bank, etc., companies subject to the CMSA listed companies cannot avail themselves of this, or companies that are under liquidation. All right, companies which are already under liquidation already have a liquidator, so they cannot have a judicial manager. Okay, but which companies can? All right, the companies that can are private companies and public companies that are not listed. Okay. You can have a senior Berhad and a Berhad as long as they are not listed. And even though they may have granted security over their assets, you can use this portion of the company side called judicial management. All right. Okay. So this is the one I think would be more commonly approached, okay, or commonly used. Okay. So what is judicial management? Well, let's go back. The process is actually the same. Who can apply? The company or its creditors, okay, in judicial management. All right. Okay. There are preconditions to this. That means, in other words, the company or its creditors must establish two things before they actually go ahead. Number one, the company is unwilling or unable to pay its debts because the company is already insolvent. Number two, the people applying for judicial management form the view that there is a reasonable probability of rehabilitating the company or preserving all a part of this business as a going concern. And that would be better than having the company wound up. Okay, I can think of a very apt situation where a test like this is right now. For instance, if you actually liquidated a company and the company's holdings are exactly, some of the securities are property based like some companies are, I'm not sure if you're going to get very good prices for them if you went off and auction them right now, because the property market right now is very soft. So it may not be a good alternative to just wind up the company itself. Okay.
Yeah.
Right. Guys, you got any question, just jump in. Okay. And I'm more than happy to clarify.
Sure.
Okay. Yeah. So now a judicial manager. Okay. Either the creditors or the company, which is essentially the directors, will need to name a judicial manager. Now, the judicial manager must also be like a nominee, an insolvency practitioner, someone who knows what he's doing. He goes into a company, he takes it over, he does his turnaround, okay, like some turnaround experts under that. Okay, what happens is that they will make an application into court, naming a judicial manager, and also setting down the basis of their beliefs why this company can turn around. Okay, you cannot go in there and just file an application there without any reasonable grounds to do so. Okay, in fact, there have been cases where people have actually filed in matters into court. All right, and the court look at this application, looks at it. This company, there is no way, it's hopelessly insolvent. The applications can be refused by the court. Right? So your application going in must have some substance, okay? And then the notice of the application has to be advertised in the English and DM newspapers and, of course, on the CCM website. And the key thing is this. The moratorium, that means the cessation of all actions against the company, commences as soon as the application to name a judicial manager is made. Okay, I'll explain this. In a corporate voluntary arrangement, you make an application into court. Usually we file all documents into court, and the court will then give you a hearing date. The hearing date can be 2-3 weeks before. Once then the hearing date comes along, you go up to the judge and you actually explain to the judge that you want to conduct a CDA. All the documents are there, all the affidavits supporting the application are there. The judge looks at it, signs it, and gives you an order. Orders it, then your CDA commences. Upon that order, when the CDA commences, that means all cases against the company all stop. Okay, that's only when the judge orders. This one is different. This one you don't have to. This one is like, let's go back. Let's say you make an application. As soon as the application is made, you advertise that an application is made, action against the company stops immediately. That means this one, you can, by the mere act of actually applying, you stop all legal actions against the company. Okay. And then maybe 3 weeks later, you get to see the judge, and the judge grants you an order to appoint a judicial manager. Immediately, you have 6 months. Okay, a moratorium of 6 months is granted. Okay, by the court. You basically don't have to worry about any other court cases for that period of time, right? And that can be further extended for another 6 months. So really, this period is that it's 1 year plus whatever waiting period you have from the time you file in the application. Okay, right.
Is this I'm just curious, because in US we always hear about companies filing Chapter 11.
Chapter 11 bankruptcy.
Is this something similar in a sense that you're putting all creditors
similar?
Relaxed?
This is in effect our version of Chapter 11 bankruptcy.
Right.
Okay, in the US code. All right. Okay. Chapter 11 is a judicial management process in itself. When they file for Chapter 11 bankruptcy, all cases against those companies also stop, just like us here. All cases stop here too. Okay, all matters are frozen. So it gives the insolvency practitioner going there time to sort the matter out itself. Okay.
Yeah.
All right. So that's a very good call. This is in fact our Chapter 11. Okay.
So that's why it was amended in 2016. That's why you mentioned.
That's right. And we were late in getting this scheme implemented. Singapore has had this since 1987. Right?
Okay.
Singapore has had this since 1987. And a lot of our provisions and the practices that we have here are very similar to the Singapore one, although it does adopt some of the British ones too. So this is our version of Chapter 11. Okay?
Okay, got it.
Okay, good, very good pick. Okay, I was about to mention that, but you beat me to it. Excellent.
Sounds good.
Okay,
It sounded like it because I'm not a legal guy, so I sounded like it from an investor's point of view.
From an investor's point of view, that's right. Okay, all right. But I have something to say about that later on at the end. Just ask me whether it's actually been quite useful or not later on. I'll talk about that when we are having our Q&A. Okay, now here. So what does the court do? Okay, the court actually has to basically look at the scheme. The scheme either has to achieve only one or more of the things. Either the company is able to survive as a result of the scheme. Okay, I beg your pardon. I should have gone back the other way. Right. Okay. Sorry. The scheme will allow the company to survive. Okay. Or that and it's more advantageous than realizing the assets of the company rather than winding up. But also, this scheme can actually be converted by a judicial manager into a scheme of arrangement under Section 366 of the Companies Act. Okay. So it can we can change it into the third type of scheme in itself if the judicial manager feels that it is necessary or advantageous. I will deal with what the third type of scheme is a little bit later. But let's go on with our equivalent of Chapter 11. Okay, all right. So you got in, you file the thing, all the court cases all come to a grinding stop. Okay, you appoint your judicial manager. The difference is what happens is once you appoint a judicial manager itself, okay, the judicial manager takes over running of the company. The board of directors are out. He's like a liquidator. He goes in there, he kicks the directors out, and he then runs the company and does everything that he has to according to the plan. But this is all very good, except there's one guy who can object, who can veto this proposal. You say you go to court, you want to actually appoint a judicial manager. The one guy that can veto this proposal, and if they say no, the courts will throw the application out, is a secured creditor who has a right to appoint a receiver and manager for substantially the whole of the assets. Okay, he or she can veto the scheme. Okay, who is this sort of secured creditor? It will be a company, or it will be either a bank or financial institution that has a fixed on floating charge over all the assets of the company, and pursuant to the debenture, that person can appoint a receiver or manager. That means to say somebody with a right to actually appoint that already can say, no, I don't want this, I want to appoint my receiver manager. The court has no choice but to actually allow that to go in.
Yep.
So there's one person that can veto it, right? Okay.
Yep.
Okay, so the judicial manager, all right? Once it's ordered by the court, of course, a copy of the order has to be in the company's company website, ROC, published in the PM and English papers, and all the creditors must be notified. That means a copy of it must be sent out to them. Okay, all right. As I said, the judicial manager displaces the board of directors and he runs the company. He's actually a very powerful person. He's actually has the same powers as a liquidator. He can basically do just about anything he wants. All right, subject to the fact that he's responsible to the court and he must run it according to the scheme. Within 14 days of the judicial management order, the company must give him all the books, all the information, all the contracts, everything, securities, whatever it is, to him. All right. He then has that. Why? Because he has to, within 60 days of the order being appointed in itself, he must send a statement on the restructuring proposal itself. Okay. He must say, this is the restructuring proposal. I'm now going to call a meeting, all right, on this restructuring proposal, and we are going to table this matter to the creditors. Okay, he's going to call for creditors meeting, he'll table it, and he's going to give his reasons why he thinks it works, what doesn't work. They may even, as they're even talking about this, even the meeting, amend or change the proposal, okay, because to suit the parties concerned. Okay, All right, and and this proposal itself again must be published in English and Malay newspapers, and people must actually know when the meeting is going to come. We're going to call a meeting. Notice of meeting goes out. All the creditors have it. There is a notice of meeting in the Malay and English newspapers, plus a address there to say where you can write to or email to. More email these days to get a copy of the entire proposal. So that he has to do that in 60 days. He actually doesn't have much time, all right, to do that in itself. Okay. Now, one thing about the judicial manager, because he acts like a liquidator, he runs the company, he even has the power to sell assets, even secured assets, subject to the leave of court. For example, if there is a bank there that has a secured asset there on a piece of property, he can choose to sell it. The bank has no say. He can choose to sell it just to cut down the debt burden in itself. Okay, this of course is subject to condition that the money raised must go to the bank. Okay, if there's surplus to the bank's debt, the money then goes back into the pool to pay the other creditors. If there's not enough, then the bank will just have to take its portion like any other unsecured creditor and continue with the process like any other unsecured creditor in the scheme. Okay, a proposal is deemed passed if it's approved by 75% of by creditors holding 75% of the debt, and these are 75% of the creditors which are present and voting. If a creditor doesn't show up, doesn't show up to the meeting, his portion of debt doesn't count in the percentage. Lucky is the company that actually owes, say, 200,000 and only 100 that creditors with only 100,000 that only shows up. All he needs is 75,000 guys holding 75,000 of that 100,000. Okay, approve the thing, and that's it. The scheme is binding on all parties, including those fellows holding the 100,000 who didn't show up. Okay, that's the example. So that's how it works in itself. The judicial manager, of course, has to report back to the court periodically how these matters are going, and then when everything is finally done, he can apply to the court to be discharged. Right? He has essentially a judicial manager has 1 year to put all these things together. Right? Usually, it takes less time in itself. If you remember, a lot of the American companies that famously went under bankrupt, Chapter 11 in itself, they're deemed to have emerged from Chapter 11 bankruptcy, emerge from bankruptcy protection, come back again, slimmer, leaner, all sorts of stuff. That's the same thing that should happen in a judicial management.
Right.
Okay, all clear? All right, okay. The third one is the last one. As I said, the process is fairly similar. Scheme of arrangement. We've always had this scheme of arrangements under Section 176. As I said, in the early days, before there were amendments to it, they were abused very badly in the days when I was still in the banking, investment banking, and it wasn't healthy for the banking system. Really wasn't. But let me dive into what scheme of arrangements are. Okay, scheme of arrangements or SOA, is open to any company incorporated under the Act. It doesn't matter if you're a bank, all right, or a financial institution. Doesn't matter if you're a listed, non-listed company. As long as you are a company incorporated under the Companies Act, you can avail yourself to these schemes. All right. So for those listed companies, those are PN17 companies itself on Bursa or financial institutions that need to go restructuring. This is the only way you can do it, a scheme of arrangement. Okay. Now, why this scheme is different? Because this scheme is, again, supervised a lot by the courts, and the courts have tremendous power under this particular section to order the restructuring of any company that is required under the scheme. Okay, in the previous two, those were basically being done by the judicial manager or the nominee. That means these were almost like private arrangements that they themselves do and agree. This one, the court actually has quite a lot to say and quite a lot they can do. So let's dive in. Okay, scheme of arrangement may be initiated by the company, creditor of a company, member of the company, or a liquidator or judicial manager. I mentioned before earlier in the judicial management slide a judicial manager may well say, I think this company, I need the powers, the court to exercise its powers to re-amalgamate and reconstruct the company, rather than me trying to do it as a private through agreements itself. I need the court to make such orders. I want to change it to a scheme of arrangement. Judicial manager, a scheme of arrangement, they can under Section 366. Okay, so you can change that into an SOA. All right. What is the applicant supposed to do? So any of these four categories of people can file a proposal or arrangement into the court, okay, and they will usually also file for an application to restrain proceedings against the company, except by leave of court and subject to conditions imposed by the court. The restraining order, the first restraining order, is usually no more than 3 months. Okay? So I apply for this. I also apply for a restraining order. The restraining order does not take effect until the judge signs the order. So unlike judicial management, you don't get immediate protection just because you put the application in. You have to wait until the order comes out. Okay, all right. The order can also be extended for another period of 9 months. Okay, the act is silent on whether you can grant further periods than that. But right now, the current assumption is that it's a 3 plus 9 months. That's it. You don't have any more time. And even the granting of the 9-month extension must have the support of 50% of the creditors, must be necessary to finish formalizing the scheme. The court must actually have all the up-to-date status of what's happening in the company, and the court will insist on nominating and appointing a director to the board of the company. Now, this director must be nominated by the creditors. So this director will then say, okay, I will look after the interests of the creditors while this process is going through. Okay, all right, look after the interest while this process is going through. Note one thing, this system under a scheme of arrangement or even a corporate voluntary arrangement, the directors do not lose their power. Okay, they are still there. They're still running the business of the company. In a judicial management, the directors lose all power. Only the judicial manager runs the business. In this, the directors can carry on running the business in its ordinary course of business, okay, while this scheme is being worked out. Okay, all right. But there are two exceptions of the restraining order. The restraining order will be does not apply to actions taken by the ROC against the company. All right, the ROC wants to fine the company for any non-filing matters like that. That one still continues, and any proceedings against guarantors. That means if banks are going after guarantors because the company has not paid it, that one is not stopped. That one continues. Yeah. Oh, so wow. It's not very comforting for guarantors.
Yeah.
No, really no fun. The guarantors are still up for it. Okay. Okay. Yeah. The court, because this may be a very complicated process, the court may appoint an approved liquidator to advise on the scheme. That means the court may say, okay, I am not comfortable with this scheme. I want an independent third party to advise on whether this scheme works or not. Essentially, the court is saying, I am overseeing this whole process. I am no expert, but I need somebody who's an expert to help me oversee this. So that approved liquidator can be appointed in itself. But he is not the one running the scheme. The scheme is usually run by what you call a scheme manager. All right, that is usually agreed by the creditors themselves. But the approved liquidator is just there like referee, making sure everybody does it right. Okay. So notices to creditors and members must explain the fee. So the proposal must actually come up, and a notice is given to creditors, members, and it must explain how it affects the creditors, the shareholders, and the directors. Okay, and also of course the usual advertisement in English, Malay papers, and also show where to attend this very important creditors meeting. Okay. Okay, so how is it passed now? This is where the law has changed. Okay, the law has changed. Previously, to pass a scheme of arrangement, it used to be 75% of the creditors the value of the creditors present and voting. Now it's different. Now it's passed if it's agreed by 75% of the total value of creditors, or class of creditors, or members, or class of members. So, in other words, as long as you can get 75% of these group of people to vote for the scheme, any one of them, all right, the scheme is actually valid. All right?
So which means
Then
the
you can go to
shareholder
court.
can also vote for this.
Even the shareholders can vote for this.
Right. Okay.
Even shareholders can vote for this, and this is new. This is very new, and really, it's interesting because I'm unsure what the policy behind this is, but I suppose the idea is that you want to make sure the stakeholders, at least members or all creditors, are treated with some equality, because they also have an interest. Creditors have an interest in the company, shareholders also have an interest in the company. Give them some say as to the survivability of the company itself. Okay, so it's interesting. It's interesting. This is a new provision. Love to know how it's going to work in practice. I really do. Okay,
Yeah.
all these provisions are new. Okay, so any four of these classes were present and voting, and it's approved by an order of the court, then the scheme of arrangement will be passed.
Yep.
Okay, all right. One of as I said, the different thing is that under these provisions, the court can issue orders to give effect to the scheme. In the other two schemes in itself, I think the EU is envisaged, the court can give directions. That's where the law says. But the court cannot give orders to say, now I want you to sell assets from company A to company B. All right. The court say, now I want to merge these two entities together. And then you issue what you call that preference shares or shares as consideration, to settle all this. Okay.
Yeah.
The court in the other two methods cannot do that. This one you can. And the advantage of the court having all these powers is that in the other two schemes, because they are seen as slightly smaller, okay, not so complicated, you can do agreements or deeds and stuff like that to put it into effect. The court doesn't have to order. This one, if for example we had to reorder, we had to restructure mask, let's say, okay, you imagine how many contracts and stuff that we will have to do. Instead of that, having a very detailed set of orders ordered by the court would be far better and more efficient. Because once the court signs off the order and issues the order, you then have a legal basis to do your restructuring without the need of having all these instruments being done. Okay? So much there. So it's far better, far more powerful. In fact, there is a specific provision, Section 371. If a company acquires up to 90%, up to almost 90% of the shares of another company itself, okay, they can compulsorily acquire the remaining 10% as part of this scheme. You know, the what you call compulsory acquisition method. So why? So yeah. So this is powerful, all-encompassing, and probably the most comprehensive way you should undertake a very large net restructure. So that's what schemes of arrangements are. All right. Okay. Right. What I've done is that I've created this comparison table. It's for the benefit of the people who download the slides afterwards. You can't see it on the screen; it's too small.
Yeah.
But it tells you what the differences are in each style. CVAs, judicial management, and schemes of arrangement, what the differences are and what the purposes are. Okay, I hope this one becomes a useful tool and guide for the people listening in and looking at this matter. Okay, so that in a nutshell is how the three ways we can actually approach and restructure debts within companies. So I'm sure there must be questions and matters like that. More than happy to answer them. Okay.
Yeah. So if you guys have any questions, Rodney is all yours for the next 10-15 minutes to answer any questions. I think he put a lot of effort in preparing that presentation. Thank you very much, Rodney, for that.
Most welcome.
Yeah, and I guess the sort of the questions. I mean, if you're an investor today, right now we're not seeing a lot of PN17 or being unable to pay their debts at this point in time, because we're still all in the safe zone. You know, obviously for public companies, they'll be using the third scheme.
Correct.
They are not
the scheme of arrangement. Yeah.
Are you? I mean, you were a previous investment banker, and now now you're a lawyer, practicing lawyer, right? Do you expect to see your business improve from you know, from that well, you know, companies in distress? I mean, coming forward post the moratorium, right?
As I said, one of the very I think the harsh reality that we have to face in this downturn is that that essentially we are facing an economy with zero cash flow. Because consumption, which takes up such a big portion of our country's GDP and economy itself, is virtually just collapsed. Okay, and the knock-on effect of that is quite severe. Many of us, of course, all will know it. We are right now essentially in a bit of a breathing space mood, because the banks have granted us a 6 months moratorium on debts in itself. Okay, but once that moratorium is over, that is where we will then see. I fear we will then see the real problems and the issues coming through. And the other thing, of course, is that the problem is we're not the only ones. The whole world is in this. You know, it's quite unlike, for example, our economy going down, and then we still had the economies of China itself all chugging along and still providing some hope as an engine to keep us afloat in itself. I remember in 2008 when the financial crisis hit. Of course, it hit very badly. Some particular countries which are very open, it didn't hit us as bad itself. But China recovered very quickly and out of that, and was able to continue to pull us out of that doldrums, and we all recovered that. We continue to have a good market there. Here in this stage, we are seeing, you know, well, not so encouraging news. Beijing undergoing a second round of lockdowns because coronavirus has broken out yet again. It is not terribly encouraging. We really need to rethink where we are in terms of our debt obligation. So I'm just saying that the mechanism for that is available. There maybe perhaps it's worthwhile looking at.
So what would your advice be for companies that are in distress and that will potentially be in distress because during the loan holiday, you know, the moratorium right now, you know, what should they prepare for? Because if they're not seeing, I mean, if they've already done all the things they could have done, cut costs and everything else, what you know, what options or what should they start doing now actually?
Actually, it's not even so much what the options are in itself. I think the both sides of the divide need to go in with an attitude that they need to help each other. Both creditors and debtors need to help each other through this point in time. Okay, because it is no use to the creditor who is trying to collect money from companies who are so distressed, thinking I can wind it up the company and then sell the asset, sell my security, and I'll recover my money. Given that the economy right now is in such a fragile state with low cash flow in itself, you may not get the values that you hope to recover. You see, and auctions may in fact fail. They may not even reach reserve, may not reach reserve prices. So it has to be an attitude where both sides must go in with an open mind to resolve an issue so that both sides can survive. Okay, because a creditor cannot survive without lending money out or doing a business out, and the debtor cannot survive if the creditor pushes them way too hard. If the businesses disappear, it's very hard to build it again. So better to try and preserve businesses than kill them through insolvency.
So basically, start a dialogue with your creditors right now, essentially
Start a dialogue with the creditor. Start a dialogue. Look at where the creditors are, what their requirements are. Start a dialogue. Re-examine your own debt levels. Re-examine your own cash flow prospects, and start formulating. You say, what is a sustainable rate? Okay, for me going forward, given the current debt structure that I have, what must go away, what can survive, all right? And that's what you really need to
do. Yeah. Okay. Actually, so if you guys have any questions, happy to answer them. We still have Rodney. Don't forget, tomorrow night we actually are hosting the Bursa session, a segment on Bursa on stocks. So tomorrow night, Saturday night, this is going to be our episode number 2. Proudly brought to you by Bursa Malaysia here at 8 p.m. Tomorrow at 8 o'clock, Saturday. So I guess you talked about how effective do you think, or do you see, do you actually in your line of work, you're saying that how effective do you think that first and second scheme is, or has that been done before?
Other countries have had them before us. Singapore, for instance, has had judicial management since 1987. But I have read somewhere that before I say that, we have had a couple of cases in Malaysia in 2018 where Malaysian companies have successfully taken advantage of these new provisions and have done a successful debt workout. It has been tried, tested, and it's proven to work. But if you were to say that it was a magic formula to solve all our problems in itself, no, it's not. In Singapore, there were some comments that are saying they were hoping they would see a better success rate. Maybe that was just Singapore, because here in Malaysia, those two cases, names that were done itself were actually touted and fated and say, if done properly, there is great prospects. Remember that these are very new provisions. Okay, so we will not see their users or reliance on it until maybe now and going forward. But up until now, there hasn't been the economy has been doing okay, so you don't see that much. Maybe now you see more.
I guess in a couple of months this will be where we'll crunch time. Okay, one question here which is quite unrelated, but it's all right. Daniel, this is a question from Daniel here. He was just saying that in your view, Rodney, do you think that your view on the legal profession, do you think that there are too many lawyers in KL? Oversaturation?
Too many lawyers. I'm not certain as to the ratio of lawyers. Okay, let me tell you, we have something like, I think if my figures are not wrong, around 15 to 16,000 lawyers in the KL, in the Malaysian bar. And I think another maybe 3,000 or 4,000 over in Sabah and Sarawak bar. So if you look at the population of the country, of 30 odd million, it's actually a fairly small ratio. It is. It's perhaps many people think there's too many lawyers because of the concentration of lawyers in the Klang Valley. Okay, they will say, all of them are over here. I don't think there's too many lawyers in itself, but I think the legal profession is changing. The sort of services and standard or expectations that clients have of us is changing, and that is the big challenge. Rather than numbers, it's actually how we do our work and how we value add to the client's process systems. That one is more important, I think.
Yeah.
Okay.
I think just for a record, I think US, I think still trumps in the world for the highest number of lawyers per capita, right? Am I right?
I don't know if that is the case, but I can tell you, law school over there is still very popular. Okay? Very popular.
So I guess the culture, if you guys, the more lawsuits and or the more legal work that needs to be done, right? When it's legal.
Well, my graduating class years ago, there were 101 of us who passed that year. and half of us never went to the bar. Half went off to do other things. Okay, some became reporters, some became news readers. A couple of them became news readers, and they all did different things. So just because you're a law degree, that doesn't mean that you have to be a lawyer. There are many other things to do. Okay. Any other questions relating to insolvency?
Thanks for tonight's session.
No problem.
Replay session. You know, I hope it helps. I got one last question that just came through from Menlo Park. He's saying that they read somewhere that the government, I guess the Malaysian government, is studying a new law under COVID-19 temporary measures bill. Is there? Do you have any idea about what this law is about? Would it be complementing corporate rescues?
Okay, that's a very very good question. Okay, Singapore passed a COVID-19 temporary measures bill very early on in April. Okay, why the bill was necessary? It had to do with essentially our Contracts Act and the provisions in the Contracts Act. The element here was to provide a way for parties to deal with very difficult contractual issues. And one of the parties, of course, is landlord and tenant. Okay, all right. Now, let's say you are a tenant in a commercial property. The business is closed during the MCO and still closed during the RMCO. What do? Do you cancel and terminate the tenancy? Most tenancies, there is no provision to call for force majeure. A force majeure has actually happened. The contract is frustrated, and there is no provision to suspend the contract while COVID-19 is going on. Okay, so there's none. Okay. Secondly, maybe there should be a way or a system like in Singapore, certain classes of contracts where which are identified, you can actually apply to a referee. Two parties go to referee and renegotiate terms to allow the business to continue or to allow some debt relief or matters like that, so that the commercial enterprise doesn't fail. So these are things that are found in the Singapore statute. We think that the Malaysian one will be fairly similar. What we still don't have any real details. We're just guessing, but we're hoping that it gets passed. The sooner, the better. Otherwise, there are a lot of issues. There still are.
Would it be retrospective in nature? Like, you go back?
I doubt very much they will be retrospective in nature. I think if they try to make retrospective in nature, then some of the whatever that has actually happened up to now, contracts which are broken, already terminated, renegotiated, suddenly you want to go back and relook at that. I don't think that would be a good idea. It's just that we are coming late into the game. Singapore did it very early. We are doing it very late. But hopefully, better late than never. It's still good to have those.
So Parliament has to sit to pass this bill, right?
Absolutely.
Okay. So we're not doing something, right?
Yeah, so all Parliament has to sit. Yes, Parliament has only sat one day since.
Yeah. All right. Thank you very much, Rodney, for joining us on the show. I hope all of you guys watching, you guys got something out of it.
Thank you for having me. It's okay. All right. And if anybody has any more questions or anything like that, feel free to send me. You can ask me by email. My email address is on the slides if you choose to download them. Okay.
The slides can be downloaded at 603-8408-2070. I repeat, the slides can be downloaded at our official WhatsApp email, WhatsApp at 603-8408-2070. So you can WhatsApp us. It's already available there. I think now you can see that our number is verified by WhatsApp as well. All right. Thanks again, Rodney. I'll see everyone tomorrow night. We have a very special session by Bursa Malaysia. See you guys at 8 p.m. tomorrow. Otherwise, that's it from us here now. Thanks again, and goodbye.
Thank you. Good night.
Good night.